If you're being charged in a district court or a municipal court in Massachusetts, you can file a motion to dismiss. The most common reason for a motion to dismiss is lack of probable cause. So probable cause is a pretty low standard, but it means there's got to be some evidence, some level of evidence where a reasonable person looking at it would determine that a crime was committed. And the way that typically works in Massachusetts state district courts or municipal courts is that a police officer will take a report. They will submit the report in what's called an application for criminal complaint at the clerk magistrate's office at the courthouse. And then a clerk magistrate will read over the complaint, usually the police report and another page or two, and they will evaluate whether there's enough evidence. Sometimes you get a clerk magistrate hearing for misdemeanors or some low-level felonies where you can actually have a hearing in front of the magistrate and argue your case as to why there isn't enough probable cause. But in a lot of cases, there's no clerk magistrate hearing, and the police simply show the packet to the clerk will look at it, and the clerk will approve it. If your attorney feels that there is not enough evidence in the police report to substantiate probable cause, then the attorney, or you, if you're representing yourself, can file a motion to dismiss. Now, for the purposes of this type of motion to dismiss, the judges are required by law to assume that every fact in the police report and in the application for complaint is true. That may not be the case. There may be false testimony or false evidence contained in the police report or the application. That is for trial. That is for another day. But for the purposes of the motion to dismiss, the motion has to be tailored in such a way that here are the facts. The judge has to presume that they are true. But if those facts don't meet every element of the crime, or there is an insufficient showing, then you can argue for a motion to dismiss. And how do you get the elements so that you can compare the facts to the crime? Well, some of the common charges, like assault and battery or drunk driving, or a whole host of other common charges, are found in model jury instructions. Now, these jury instructions, of course, are meant for cases that go to trial, and that is the instruction that the judge would give to the jury. But they're broken down into various elements, so each charge has a certain number of elements that must be met. At trial, the standard is higher. That's beyond a reasonable doubt. But you can borrow them and use those for purposes of arguing that there's not probable cause in the application for criminal complaint. If there are no model jury instructions, the attorney can look to case law. They can look at appellate court cases that have analyzed what the elements of the particular crime are and find it there. In some cases, that's not available either because there just haven't been any appellate cases analyzing those elements of the crime. So in those circumstances, the attorney would have to look at the statute itself and sort of fashion what the most appropriate elements appear to be based on the legislature's wording of the statute. So in those hearings, again, the judge will presume everything is true as given to the clerk magistrate, but in a lot of cases, there just isn't enough probable cause. Even believing all the facts as true, there might be an element missing. And even if there's one element missing or multiple, that can be enough to get a case dismissed.